Follow the erudite challenge set out by the Honourable Clayton Cosgrove. His challenge puts the responsibility of victims' rights squarely in the hands of the government, who do need to do more. Labor's record of victims' rights and standing for victims' rights clearly sets out our commitments and our actions in the past to address the interests of victims. And I just want to outline that for the record. We introduced and passed the Sentencing Act in 2002, which introduced a presumption in favour of reparation and resulted in the sentences being used more frequently. That same Act also recognised the potential of restorative justice processes to make offenders more accountable to victims. It enabled courts to take both financial and non-financial offers of amends by an offender into account. Labor introduced and passed the Victims' Rights Act in 2002, which extended a number of rights to victims, such as rights to information and the ability to have input into sentencing decisions through victim impact statements. That in itself had a transformative effect on addressing the rights of victims, and in terms of practical examples that have come through my office, it made a big difference. In 2003, the Ministry of Justice launched a campaign to trace those owed money, introduced an 0800 number, and also established new collection centres to further bolster the collection and disbursement of reparation. We passed the Prisoners and Victims Claims Act, as Clayton Cosgrove mentioned, in 2005, which ensured that victims of inmates awarded compensation could claim against that compensation. We introduced the Pay or Stay initiative in September 2006, enabling the Ministry of Justice to stop people with unpaid fines or reparation if they were travelling overseas or returning to New Zealand. The Evidence Act and the changes we introduced there in 2006 provided for the needs of vulnerable witnesses and victims by making provision for witnesses to give evidence in alternative ways, such as giving evidence from behind a screen via CCTV and pre-recorded video. Victims of sexual offence, for example, utilised this particular mechanism. When we amended the Children and Young Persons Act and their Families Amendment Bill, we included a provision to ensure that victims of youth crime could attend youth court hearings, and also had provisions to ensure that these victims were kept informed of proceedings. In 2008, a Victims' Charter was developed to build awareness of the standards of services that victims could expect from government departments, and we know ACC in particular was a government department where a number of concerns were raised with regards to the handling of sensitive cases. An 0800 victim helpline was also introduced in that same year, a website for victims and a boost of funding for victim support who offered much needed services in many communities. All these types of initiatives all built a profile of ensuring that the rights of victims were continuing to be addressed. Mr Speaker, what we also did was we announced that we would provide additional services in 2008 through family violence courts, such as the introduction of an independent victim advocate or support person to provide support and assistance to victims of domestic violence. And I know in many communities that I support that this is indeed an important service that was utilised quite heavily to ensure that those suffering from domestic violence were able to be supported. We also asked, Labor did, asked the Law Commission to look at how to set up proper victim compensation schemes, and I understand that that work is still continuing. So what we know, Mr Speaker, is that this particular bill is an extension of gains that actually Labor made, and we're happy to support it. It's a minor technical change that is going to be considered, and that we want to ensure that the big picture in terms of how national addresses victims' rights would have to supersede the record that has already been established by Labor. So it's just not good enough in terms of the ACC issues raised by Clayton Cosgrove not to provide an avenue for those who have suffered sexual abuse, not to have a remedy for reparation and have their needs addressed. I know from particular cases that ongoing support, mental health and counselling support are very much needed services, and it's just absolutely reprehensible that those types of supports may not continue to be available. Mr Speaker, I didn't intend on taking a long call on this part of the bill, and as we've said, this is a minor technical change, but let the case state that Labour's record in terms of advocating for victims' rights stands in its own right.
I call David Clendon.
Thank you, Mr Speaker. Kia ora koutou. So when this Act, this Prisoners Victims Claims Act, was first proposed prior to 2005, the Greens opposed it essentially on the basis of the effect on human rights and the reduction of human rights and the various what's now proven to be the case, that it was likely to be ineffectual and most of the effects would be negative with very few positive elements or redeeming features to it.